It is great to have you with us today. We're covering radical eviction trends impacting your investments. And this is information it's not good news information, but it's information that's critical to have nonetheless. And we're going to do everything we can. And we need your help. We need everybody to respond as much as possible whenever we do mobilize the troops. But here we go. And before we get into everything, I know a lot of you have signed up for the rent reporting. This is a new service that AOA is offering to its members. So if you have a building that is more than 15 units and you need to do the rent reporting, you need to offer it to your people. If you need to do that, we have a service where you can give us the information and then we can report that to TransUnion on the behalf of your tenant. We call it a white glove service. So you don't have to subscribe to any software to do it, and it's just month to month. We do have software as well that does it. The white glove service is $5. The software has a subscription fee that's $15 per month, but the rent reporting part of it's free. So anyway, and it's free for a limited time, and it'll be free for the people that sign up as long as they're on it. So it really is a great time to get started with that. Either way, that's just one of the many benefits that we have. If you're not a member, I want to encourage you to join. It's $97 for the year, and there is no per unit fee yeah, and so here we go. We got a couple events to talk about. There's the big AOA $1 million trade show that's coming up on, what is it, April 16th, which is next Wednesday, April 16th at the LA Convention Center. And so definitely mark your calendar. And if you haven't registered, I know we have literally thousands of people have already registered for it. But if you haven't registered, register online, and it makes getting in a little bit smoother. And so register, and we really look forward to seeing you there. We're going to have over 20 different seminars going on. We're going to have, yeah, there's definitely over 150 different vendors that'll be there. And these are, the vendors, some of them stay the same, but there's a lot of new ones as well. So there'll be new people for you to meet and source the things that you need to source for the work you're doing in providing housing. So we're really excited about that. Just the opportunity that's there to get ideas and streamline things, make it a little bit easier. And yeah, let's see what else. And then in May, it's not a trade show, but it's a power conference, and it's the San Diego Landlording Power Conference that we're going to hold in San Diego. So that'll be fun. That one, the seating is limited. It's a smaller event. We're going to have, I think, 6 different speakers and some vendors there. Both of those are going to be great. So if one's closer to you, then go to the San Diego one, or if you can't make the LA one, then go to the one in San Diego. The San Diego one will have some things that relate to everybody in most of it will relate to everybody in California. The eviction attorney that's speaking, what he covers will relate to just about everybody, but there'll be the specific San Diego stuff that will be beneficial for the local members there. And some of the other speakers are local, but all of it is going to be great and similar to a trade show. So here we're going to get started. Our speaker today has been in the industry, the rental property industry, for over 25 years, 16 as an attorney, and he's the president and founder of Brennan law firm, and they do landlord tenant litigation and evictions. And he's written articles. He's is on different legislative committees, so he gets information before most people do. And he's just just very well informed. And so it's really just a blessing to be able to bring someone on like this to add value to your AOA membership. So Mike Brennan, thank you so much for joining us.
Good morning, Jeff. Thank you for having me.
And I'll let you take it away.
Okay. So like Jeff said, the information I'm going to provide today isn't necessarily information that's going to brighten your day, but it certainly is information that you guys will want to know. Some of it are will include laws that have already been passed that are going into effect. Some of it will include laws that have been passed but haven't quite gone into effect yet, and some of it's going to include proposed legislation that is floating around Sacramento right now. So with that said, I do want to state with regard to these new laws, it's important to understand that they're brand new or they haven't even been passed yet. So there's no case law on them. There's no interpretation of them yet coming out of the courts. And of course, there's various opinions about how they should be applied or how they will play out in court, depending on which attorney you talk to. So the key to remember here is that they're brand new. They haven't been tested. They haven't been ruled upon. And so there's no legal advice. Don't take anything I'm giving you today as legal advice. Every situation is going to be different, and every building is different. Virtually every city's got its own rent control or just cause. And so before you try to apply something that you hear today to your buildings, just make sure that you talk to an attorney about it first. Having said that, let's jump right in. As Jeff mentions, this is radical eviction trends impacting your investments. Not just eviction trends. I should have named it radical legislative trends that are impacting your investments. And they, as you will see as we move on, they really do impact your investments, your returns, and you're going to need to modify your strategies as a result of some of these, assuming they pass. So let's take an overview of the topics we're going to talk about today. We'll talk about the important new laws impacting your investments, the one that went into effect. I still have people calling me saying, hey, I just heard about this. Can you explain it to me? And so I think it's important to hit the highlighted laws that it went into effect. Then we're going to talk about the proposed laws that will radically alter the returns and on your investment and your strategies. And this, again, you're going to have to develop these strategies, assuming these laws actually go into effect. And then finally, I want to show you how there's an alignment taking place of state and local municipalities that is going to force you, all this plays out, it's going to force you to house tenants who don't want to pay their rent indefinitely. And then we'll talk about some strategies. What can you do? We've got some proven strategies that have gone over the last decade or so, but they haven't been implemented enough to have avoided some of the stuff we're going to talk about today. So hopefully we can change that. So let's jump into important new laws impacting your investments. And again, this is not exhaustive. This is just the ones that I keep having clients call me about. So first, screening fees, screening policies, and credit reports. This is big. There are some prohibitions on screening fees now. Landlords are prohibited from charging a screening fee if they know or should have known that they didn't have a unit available, or if there was no unit available within a reasonable period of time of somebody applying. Mandatory screening policies. Now, based on this new law that went into effect, AB 2493, you have to pick your policy. I know a lot of landlords have been told over the years, oh, you have to take the first come, first qualified applicant. And as I've always said, that's actually not true. It's a myth perpetuated by fair housing. In fact, I just took a fair housing certification course a couple weeks ago. Yes, I do myself attend these classes as well. And the fair housing advocate in there admitted that while that is not the law that you take the first come, first qualified applicant, it is the direction that the state is going. They are trying to push landlords into that position where they have to take the first come, first qualified, which obviously everybody knows that's not the optimum outcome for any sort of a landlord. So what are your options? Option number one, you can only charge an application screening fee when the applicants are provided your written rental criteria together with the application form, and you process the applications on a first come, first qualified basis. So that's option number one. If you're going to do that, if you're going to hand your criteria out with your application and you agree that you'll take the first come, first qualified, you get to charge the screening fees. Option number two, you're not required to accept the first qualified applicant, provided you return the fee to any applicant who is not selected within the lesser of 7 days or after the tenant selection, or 30 days total. So you have to return their fees. If you're willing to do that, then you don't have to take the first qualified. So as Jeff was talking about earlier, I suggest you just use a third party. Don't collect the fees. Especially for the price Jeff is offering, let them do your screening. I know his pricing was talking about the credit reporting. but I know their pricing on the screening is also fantastic. So just farm it out to a third party, let them deal with it, and this way you never have to take the fees, and you get the reports. The reports are good. If they're still using the same company, it gives you an ABC, and do it that way. Don't touch the money. You don't have to return anything, and more importantly, you don't have to take the first come, first qualified. And then finally, there's some mandatory credit reports. All landlords now are required to provide the applicant with a copy of the consumer credit report that they obtained within 7 days of receiving the report, and it can be sent by personal mail, personal delivery mail, or email. So like it says at the bottom there, my approach would be use the third-party vendors and have the application screening fee paid by the applicant to that third party. Okay, next law that's important to know, AB 2801. It's a very subtle change in the law. I've talked about this several times throughout this year already, but it's a very important change in the law. The law is now focusing on what's called reasonably necessary. Now, that's always been in the law, but now the way they subtly changed the law, landlords are required to really prove that any charges against the security deposit were reasonably necessary. And so these reasonably necessary limitations apply to materials or supplies, as well as the labor provided by the landlord, their employee, their contractor, or even a carpet cleaner. So what does that really mean? Let's say you have a policy that you clean carpets when tenants leave. You are no longer allowed to just have that as a policy. If you want to use a professional carpet cleaner to clean those carpets, you have to demonstrate that it was reasonably necessary to have the carpet cleaned. Okay, so how do you do that? Well, that ties into these new photo requirements. You're now required to take 3 separate sets of pictures. There are some trigger dates. One has already passed. I wouldn't worry about the trigger dates at all. I would just start doing all 3 sets immediately. You are required now to take a picture of the unit and the conditions within the unit at the inception of the tenancy. And you're also required to take a picture of the unit within a reasonable amount of time after the tenant vacates the unit, but before you implement any cleaning or repairs or maintenance that were beyond ordinary wear and tear. And then you're required to take this 3rd set of pictures after the cleaning and repairs have been completed. And you've got to provide those pictures along with your security deposit accounting. So as you can imagine, it might be hard, especially if you have, for example, beige carpet. It might be hard for you to really capture in a picture the condition that made it reasonably necessary to hire a carpet cleaner. But nonetheless, that's what your obligations are now. So you're going to have to do it. So do your best. I keep saying it, it's not a joke. You can hop on YouTube and find videos on how to take good pictures that can really pull out some of the conditions. And I've been doing it for years. I've sent tenants after their tenancy stacks of pictures this big with their security deposit accounting, just to prove all of the charges that I've taken out of their security deposit. So it can be done. It's somewhat of a pain in the rear, but now it's law. Now you actually have to do it. You are still allowed to do itemized deductions, but you're still required to do them. But you actually have to include the photos with a written explanation now for the costs of the repairs or cleaning. In other words, why was it reasonably necessary? That's got to be in your accounting now. And then finally, on this law, the parties can agree after the termination of the tenancy that the accounting can be sent by email. So if you don't come to that agreement, let's say you're in an eviction and after the termination of the tenancy, you're not really talking to your tenant, I encourage you to still do the accounting, still do everything you're supposed to do under this new law, but send it certified mail, no signature required, to the tenant's last known address like you've been doing forever. All right, that's 2801. Let's see, we've got AB 2747 and SB 924. This is specifically what Jeff was referring to earlier. Mandatory offer of positive credit reporting requires all landlords of residential properties to offer all tenants positive rental payment reporting to at least one nationwide consumer credit reporting agency. Okay, the trigger dates involve the leases. When did the lease take effect? For leases that were in existence as of January 1st, 2025, you've got to do this on or before April 1st, just passed 10 days ago, and annually thereafter. So in other words, you have to do it immediately. And every year after that, you have to offer them that same right to opt into the credit reporting. And for leases entered into after April 1st, 2025, you've got to do it upon the execution of the lease and annually thereafter as well. You are allowed to recover your costs. Yeah, it's the lesser of either your actual cost or $10 a month. Jeff's pricing is fantastic. If you do the math, it's going to come out to less than $10 a month. If the tenant opts out or fails to pay the fee, there's a 6-month waiting period before you have to offer them that option to opt in again. And so what's the remedy if the tenants fail to pay the reporting fee? There's not much you're allowed to do. You're permitted to terminate the reporting if they fail to pay the fee. If it remains unpaid for a period of 30 days, what you're not allowed to do is you're not allowed to use the rent to pay it. You're not allowed to use the security deposit to cover it. And you're not allowed to file an eviction based on that failure of paying that fee. So let me stop here for a second. We're about to talk about the exemptions. Now, you can look up the language in AB 2747. There is some disagreement as to who this applies to, who is exempt, who is not exempt. I've spoken with probably 6 attorneys now. We all read it similarly, but there's definitely 2 camps. So let's go through this. It says landlords who own a property with 15 or fewer units are exempt unless both apply. So let's stop there. It says a property. I think in the law it actually says a residential building. That's singular, okay? But what causes the confusion is the next 2 subparagraphs, which state that landlord is exempt unless both apply. So landlord owns more than one residential rental building, and the landlord is a REIT, a corporation, or an LLC with a corporate member. So where the attorneys are differing is when you ask the question, is a landlord who owns 2 fourplexes exempt? Some people say, yes, they're exempt based on this language because both of the 2 subparagraphs have to apply. Others say, no, the fact that the law said a residential building means the exemption only applies if the landlord owns a single building. As I said at the beginning of the webinar, there's no case law on this. It's very poorly drafted. It's not clear at all. There is no case law. It's never been in court. It just went into effect, essentially 10 days ago. And so, in my opinion, in an abundance of caution for landlords who own multiple buildings, you might as well comply until there's some sort of definitive opinion that comes out that says, yes, this exemption would apply if somebody owned any number of buildings with less than 15 units, or an opinion comes out that says, no, it's only for landlords who own a single building with 15 or fewer units in that building. So again, in order to make sure you're in compliance with the law, the path of least resistance is to talk to Jeff, sign up for the service. I personally have been saying this for years. This law actually passed for rental assisted units last year, a couple of years ago, I forget, where you had to offer this to tenants receiving rental assistance. And so I personally think it's a great idea. I wish all landlords were doing it because, again, as I've said many times, this is a way to circumvent the state's law that seals all eviction records. If you've got a tenant that is the landlord is positively reporting credit over and over and over, and all of a sudden 3 months ago, that positive reporting stops. While it's not a conclusive piece of evidence, it is strongly suggesting that that tenant failed to pay the rent or is in an eviction right now. So again, I think there's some hidden benefits to it, and I hope the whole industry jumps on board and moves with it. Okay, let's see. So those are the highlight of the big laws that went into effect for 2025. I want to jump now into the proposed laws for 2025 and 2026 that I think are pretty radical. And we won't talk about every single law that's proposed out there. These are only the laws that I think impact landlords or will impact landlords the most. So I'm going to start off with SB 448. This is the trespasser squatter removal. This creates a procedure for the notice and removal of a squatter by a local law enforcement agency, and it defines a squatter as somebody who unlawfully enters a residential property and refuses to leave after being requested to do so, or someone who falsely claims the legal right of possession. What this does is it allows the property owner or their agent to serve a demand to vacate like a notice to terminate, similar. And then after the service of that demand, to submit a request to the local law enforcement agency to remove the squatter. Now, I hope it passes. It's fantastic. The law itself has fantastic intent. I don't know how effective it will be. There are similar laws that allow some landlords to remove various people from their house right now under a very similar situation. And when you call the police out to do that, their typical response is, this is a civil matter, you've got to file an eviction. So again, I love the intent behind the bill. I hope it passes. But more so, I hope that the local law enforcement agencies will honor it. It does offer them immunity from lawsuits for doing so, and that has always been the big concern among them in the past on those other laws that I was talking about. All right, AB 246. This is huge for everybody in LA. Los Angeles and Ventura counties. This law, if passed, is going to be a rent rollback and a freeze. It's going to prohibit owners in Los Angeles County and Ventura from charging a rental rate in excess of the rental rate charged on January 7th, 2025 until March 1st, 2026. In other words, there will be no rent increases on any residential rental in Los Angeles or Ventura County until March of 2026, regardless of whether the tenant was impacted by the fires or not. So every single residential rental unit in those counties would be frozen on rent increases. What's the status right now? It's pending in the Senate Appropriations Committee, but it is an urgency bill. So it can pass rather quickly, and once it does, it can go into effect right away. So just keep that in the back of your mind. I know the CPI numbers are going to come out, and when they do, there will be many landlords in Los Angeles County implementing rent increases. Keep in mind, not only does the increase have to be the right amount, but if this law passes, you could be forced to roll those rent increases back. And by the way, for those of you thinking I just won't do it, if you didn't do it, it would be an illegal rent increase, and every single rent increase that you implemented after that would be illegal as well. All right, SB 522 is a post-disaster rent-controlled units. So this says it excludes housing built to replace a unit that was substantially damaged or destroyed by a disaster from the exemptions it may have had under the Tenant Protection Act. So what does that mean? For those of you whose properties are covered by the Tenant Protection Act, you know that if you have a certificate of occupancy that was issued less than 15 years ago, your property is actually exempt from the Tenant Protection Act. What this bill would say is if a property was destroyed that had tenant protections and now you rebuilt that property, you're going to get a new certificate of occupancy. And this law will say that just because you have that new certificate of occupancy now that is less than 15 years old, you will not be entitled to the exemption from the Tenant Protection Acts that you were, from the tenant protection laws that applied to the building before it was destroyed. Okay. When you see red, that's the radical. So SB 1157 is being proposed right now. We just talked about Tenant Protection Act and exemptions, and most of you, certainly everybody who's under the Tenant Protection Act probably knows that the Tenant Protection Act removes, or this law, well, let me start by saying this. It exempts single-family homes where the single-family home is the only building on the lot, and the landlord is not a REIT, a corporation, or an LLC with a corporation as a member. What this law will do if it passes is it's going to remove that single-family home exemption entirely from the Tenant Protection Act. So in other words, those single-family homes will no longer be exempt from rent control or just cause under the Tenant Protection Act. It also is intending to reduce the permissible rent increase amount from 5% plus CPI to 2% plus CPI. So you're going to lose 3% right off the top there. And it's going to permanently remove the 2030 sunset date that the Tenant Protection Act had. If you remember, it was a 10-year law, went into effect 2020. It had a sunset or has a sunset date of 2030. If this law passes, that sunset date will go away again. So there's an Arabian proverb that says, once the camel's nose is under the tent, soon thereafter, the entire camel will be inside the tent. And you witness this in California all the time. They passed this law in 2020, the Tenant Protection Act. It was a fairly straightforward and watered down version of rent control and just cause. Easy to navigate. I thought it was fair and reasonable for both sides once it passed because it was easy to navigate. And slowly over the years, and it's ramped up since COVID is gone, but slowly over the years, they are now eroding the protections in there. So, for example, you used to be able to do a substantial remodel for any situation that would have required a permit. Now, I think it was last year, possibly the year before, I forget. It may have gone into effect last year, but I think it was voted on the year before. They've removed that. Now there's a whole series of things you need to do to be able to be in compliance with a substantial remodel to be able to terminate that tenancy. Owner occupancy, they've narrowed that exemption down, or not exemption, that basis down as a reason for terminating tenancies. Now they've added new requirements, new administrative hoops that landlords have to jump through to do an owner occupancy. And this is just the next step along that path of whittling away landlords' rights and implementing more obligations on the part of the landlord while increasing the protections for tenants. So, like I said, this is kind of radical, but it gets worse. We'll talk about that as we move on. All right, now let's talk about the alignment of state and local municipalities that's radically altering returns and strategies. Let's jump right in here. I want to show you some laws here, and I'll show you how I'll tie them all together in a minute. So under California Civil Code 1947.3, which was passed relatively recently within the last few years, it specifically states that a landlord or a landlord's agent shall allow a tenant to pay rent through a third party. What does that mean? Well, it means you actually are required to take rent if that rent is being paid to you through another individual or from another individual, from a charity organization, from a rental assistance program. You are mandated to take that money. Under this law, there are some certain requirements. The tenants have to do some certain things and present you with some certain documents before you're actually forced to accept that money. But in most situations, they don't do that. But this is where it all started about 3 or 4 years ago. California passed this law saying you have to take money from a third party. Okay, let's look at the Los Angeles County Anti-Tenant Harassment Ordinance. So that states that it's a violation of the ordinance to refuse to acknowledge or accept receipt of a tenant's lawful rent payment as set forth in a rental agreement by usual practice of the parties or in a notice to pay rent or quit. So this one adds that it's a violation to take that not to refuse to take that payment. And I accidentally left the language out in here because I was deleting certain things, but it includes a third party. So Los Angeles County's anti-harassment ordinance requires you to take this rent. Now let's look at Los Angeles City's anti-tenant harassment ordinance. It specifically states it's a violation to refuse to acknowledge, facilitate, or accept receipt of lawful rent payments or rental assistance payments as established by applicable law. Well, I just showed you that California says you have to, LA County says you have to accept these third-party payments. This one includes refusal to accept rent paid on behalf of a tenant from a third party or refusing to timely provide a W-9 form or other necessary documentation for the tenant to receive rental assistance from a government agency, nonprofit organization, or other third party. So you're violating the anti-harassment ordinance if you refuse to accept these payments from third parties. All right, so what if you do? What are the damages? Under this law, it just recently passed that there are mandatory damage awards of triple compensatory damages. Compensatory damages are whatever the tenant suffers as a result of your refusal. So, for example, if you don't take the rent from the rental assistance program, or you don't help facilitate the tenant's application for that rental assistance program, and let's say you evict the tenant, or the tenant ends up moving on its own because they can't pay you that rent, and they can bring this action against you that you violated the anti-harassment ordinance, and they get triple whatever their costs were, which could include increased rent. And we'll talk about that in a minute as well. It also includes damages for mental and emotional distress and a minimum civil penalty of $2,000 per violation. So what the city of Los Angeles did by passing this is they set in motion these significant civil penalties against landlords who don't want to accept payments from, for example, rental assistance programs. Why did this take place? Well, you might remember during COVID, there were rental assistance programs that were asking landlords to comply. And if I remember correctly, that the California law had already passed saying you have to take these third-party payments. But those rental assistance contracts required the landlords to waive their rights. So in some situations, it required a landlord to agree that they wouldn't evict the tenant for a year. In other situations, it required the landlord to say they wouldn't evict, but they also wouldn't increase their rents. I've received multiple letters in the last couple of months from these rental assistance programs directed at my client, but those letters specifically require the landlord to sign a contract to help get the application flowing. But that contract requires the landlord to waive its right to increase rents for the next 12 months. Each time I've gotten that letter, that's what it said. So you put these all together. Now, are you required, is a landlord required to sign a contract waiving their rights? My position has been no, and we have told the rental assistance program and the attorneys that sent me the letters that from our perspective, we're not while we may be required to help facilitate the payment, as part of that facilitating, we're not required to waive the landlord's rights. And so that's going to be an issue. What I can see happening is over time, as landlords balk at those type of contracts, they'll remove those requirements to waive your rights, and you'll be forced into taking these payments from third parties. Okay, now let me jump over to a different swimming lane for a second. Let's talk about this other new law that's being proposed right now, SB 436, reinstating evicted tenants. And then I'm going to tie all of these together and why I think this is just a radical move that has been in the works for several years now. This would require a judge in an eviction to restore a residential tenant to their former tenancy if the tenant pays the full amount of rent in arrears. Now, many of you are saying, well, they couldn't pay their rent, so I'm not worried about that. Right. Or they submit documentation of approval for rental assistance funds in an amount that would cover the full amount of rental arrears. So now think about those mandatory third-party payments we were just talking about. So what this says is, let's say you go through an eviction. Well, let me keep reading for a second. The tenant is not required to demonstrate any sort of hardship, and where the tenant tenders payment or documentation before a judgment is entered, meaning they either give you the payment or they produce a letter that says they're approved before the entry of judgment, the plaintiff must file a dismissal with prejudice, which means you'd never be able to bring the case again for that unpaid rent. If the plaintiff doesn't do that or refuses to do that, the court has to dismiss the action. All right, but it gets worse. Where the tenant tenders that payment or provides proof that they've been approved after the entry of judgment, but before the lockout, the court must set aside that judgment against all of the defendants and restore the tenancy. So what impact is this going to have? You're not going to market on those units. So let's say, so essentially what the state is doing and what the local municipalities are they're circumventing protections from Costa-Hawkins. They're implementing a form of rent control by rewriting what are known as the state's forfeiture laws. So what the forfeiture laws say is when somebody breaches a contract, the court has the right to forfeit that contract. In other words, they unwind it. They say there is no contract. We're canceling the contract. In the case of evictions, landlords, when they serve the notice, the notice will say the landlord hereby elects to forfeit the contract or forfeit the lease. What this law is saying is you can serve your 3-day pay or quit. You can go all the way to a jury trial. You can conduct a jury trial at expense to you. You can win that jury trial. And on top of all of that, the tenant can now come to you, force you to cooperate with the rental assistance program by filling out the forms, providing a W-9, and ultimately accepting payment from that third-party payor. And if they do all that, guess what? You're not getting your unit back. You're not getting compensated for your attorney's fees or your court costs, and you're putting those tenants right back into possession of that unit, and their entire tenancy will be reinstated. So if you tie these laws together, the anti-harassment ordinances are saying we're forcing you to take these payments and we're forcing you to cooperate. And this law, if it passes, is saying on top of being forced to cooperate with that, you're going to have to cooperate. And if the tenant can show up before the lockout, then with a letter that says they've been approved, their tenancy is reinstated. You're not locking them out, and you're not going to market rent on that building. or that unit rather. So you can see that's pretty radical. Many investors out there, there's some natural turnover and then there's some evictions. One way or another, units tend to turn, and that allows many members to stay in business because eventually they can take a unit to market rent. With these laws that are being passed, it appears to me that the whole intent behind all of that is to prevent landlords from going to market rent any way that they can. You saw them reducing the permissible rent increase under the Tenant Protection Act from 5% plus CPI to 2% plus CPI. We saw the county last year reduce the allowable increases to 60% of CPI. We see the county and cities and state forcing landlords to take money from third parties, which could include voucher programs, Section 8, rental assistance programs, churches, anybody. Now we see them saying, hey, even if you go all the way and you win, the state legislators are going to rewrite the forfeiture laws and force you to keep that tenant. So I think, again, these are radical laws that are going to impact your investments, your return on those investments, and we've got to come up with some strategies to circumvent these laws. All right, so what are some of those strategies? I'm going to start off before I start reading that by saying every time statewide rent control has come on the ballot, that's 3 times in the last, I don't know, 5 or 6 or 7 years now, we've beat it. How did we beat it? We beat it by coming together as an organization, as an industry rather. Everybody came together, everybody pitched in, everybody started contacting their representatives. The whole state pitched in, all of the landlords. It wasn't just the landlords, it was the landlords, it was the apartment owners associations, it was the realtor associations. Everybody saw the stupidity of those laws and we beat it. But unfortunately, the entire industry doesn't coalesce like that when we start seeing laws like this. And that's got to change. So you've got to build your team of people. You've got to join a team of people who are effective at fighting this stuff. You've got to use your recognized industry professionals, and you've got to get involved and participate in the civics process. I know when I was in high school, they actually taught civics. They haven't taught civics since a couple years after I graduated high school. They don't even let people know what it means to be involved in civics, let alone how to participate in civics. So civics simply means you're involved in the political process. You've got to attend your city council meetings and your county supervisor meetings. Again, talk about successes. When wildfires were ravaging and the city of Los Angeles attempted to implement an eviction moratorium, what was called an eviction moratorium, multiple times, what happened? The housing providers showed up, and they showed up in large numbers with yellow signs that said, "We house LA," just like the tenants had been doing for 15 years prior to that. And what happened? They beat it. LA did not implement that moratorium. I believe it was 3 times. It was either 2 or 3 times they shot it down, and ultimately they left it alone and walked away from it. So I've got a link up there, https findyourreplegislature.ca.gov. I really encourage every one of you, when you hang up from this webinar, jump online, find out who your representatives are. I'll email Jeff the slides so that Jeff can distribute them to anybody who wants them. Look at those bill numbers and start reaching out to your legislators and saying, hey, look, this is crazy. This is beyond reasonable. It's even beyond unreasonable. It's radical, inappropriate, and just certainly unfathomable that California and the local municipalities have chosen and continue to choose to villainize landlords, to attack landlords, and to hang the financial burden of every disaster or potential disaster that comes along on the shoulders of landlords. But if you don't reach out to your representatives, they don't know that it's affecting you. And then finally, I'm going to tell you to donate to remove problematic progressive Democrat socialist legislators. Okay. Even if they're not your representative, such as Wahab, she is driving a lot of these bills. And if you can contribute to either other legislators that want to run or PACs that are fighting to get rid of her, if the industry came together to fight these radical legislators, then you could get them out of office. I know that a lot of them receive their funding from NGOs, and that's been in the news quite a bit lately as Doge uncovered how the funds travel from organization to organization to be used for purposes that they weren't designed. Well, that certainly takes place in California in political circles. They're well funded. If you want to get them out of Sacramento, and I honestly believe unless you want this industry to basically disappear and all of your hard work go down the drain and have it negatively impact your grandchildren, your great grandchildren, you need to remove these people from their office. Then you've got to get involved. There's got to be some coalescing in the industry to fight these laws to the same degree we have fought statewide rent control and won in the past. So that's the slideshow. It was rather short today compared to the other ones that we typically do. But I hope the information that I provided was valuable. I've been speaking to a lot of landlords over the past couple of months who had no clue that these bills were being floated around up in Sacramento, didn't have a cohesive idea about the bills that had already gone into law and how they should be applying them. Like I said, this is a high level 40,000 foot overview of the most important ones. Hopefully, we can defeat them. And if you have any questions, Jeff, I'm happy to answer them while I can.
Awesome. Thank you so much, Mike, for this. And yeah, we do have questions here, so we'll just launch right into it. And remember, like, you're going to be, I failed to mention it, but you will be speaking at the $1 million trade show
That's right.
uh, next week on Wednesday, April 16th at the LA
Correct.
Convention Center. So here we go. And you're not just speaking there, you're there all day. I see you fielding questions all day long
Yes.
there. So it's great. Thank you so much for doing that. And
Sure.
it really will be awesome. So come meet Mike and his staff. Let them take care of you. All right, here we go. Brown eyes. I'm a little confused. I have two 4-unit buildings. Do I have to report tenants' rent to the credit bureaus?
So you are among many who are confused. Like I said, there's uh, even attorneys are differing in their take on this right now, and there's no case law, no guidance. It's very poorly drafted. Like I said, I suggest that for right now you comply so that you're in compliance with the laws until we can unpack this and figure out, whether people who have less than 15 units but spread out through multiple units, I mean multiple buildings are exempt.
Yeah, when people have called in, I've just been telling them, listen, if you don't have a 15-unit building, or if one of your, or if even if you have several buildings, if one of the members of your LLC isn't a corporation, then you don't have to comply with it. I guess I'm more in the other camp, you know, as far as not complying, but I agree with you 100% because on the just it's a best practice in a sense because at least you can reward your the good renters, you can reward them by helping them build their credit. And I did make a note of that, like, so let's say you do see on the credit report that trade line that shows that they've been paying the rent every month, and then all of a sudden there's a gap there. Do you think you could legally use that to give them an adverse action and tell them they can't,
So
that you're
I'm
going
glad you brought that up because Jeff, you guys went out and proactively looked into the laws that allow a landlord to negatively report credit. I do, correct me if I'm wrong, but I believe you're offering that service, aren't you?
Yeah, so only, it's funny that one, not to confuse the current 1157, but the one with Section 8, it's positive and negative. So if it's a Section 8 tenant, the way the laws, there's two different things that are written. So if it's Section 8 tenant, you can report everything. If it's not, you can't. I have hired an attorney. I was looking for a way to do it where you could report it, but then I looked at the contract that we have with the credit bureau, and they're not allowing it. So beyond what's in California code, if you have to have the permission, the consent of the renter to do the reporting. So you can't forcibly do that while they're in the unit for rent. Obviously, if they're out, you have a judgment against them. or they just skipped out and they owe you money, you can definitely report that to, send it to collections. It's going to be put on their credit report. But that's different. That's post. So
Well, let me unpack that a little bit more. The
yeah,
law does not prohibit not the Section 8 law, the non-Section 8 law. That law does not prohibit negative credit reporting. So there's no language in there that prohibits it. All it says is that you've got to offer them positive credit reporting. Or at least the last iteration of the law that I saw didn't have a prohibition. You're
right. So
smiling.
yeah, so you offer them positive, but then how are
Right.
you if they decline, how are you gonna start reporting positive and negative?
Right. So there are laws. You and I have discussed this a little bit through email. There are laws that address negative credit reporting, and their landlord would have to comply with certain notice requirements to report negatively. I
Right.
think in the end, because it's not prohibited, the industry as a whole will be able to find that way that we can report the negative. I think the laws are there that
Right.
would permit it as
So
long as the notice is requirement is met.
right. So what I'm saying is like the laws are there, but then when you go and interact with TransUnion or Experian, like
Right.
we sign a contract to be able to report to them. In our contract, what we have to comply to is that the tenant has consented to the reporting. So if there's a way to, so without their consent, we can't report it based on so I just dug into it. I looked at the contract that I had and realized that I can't do that, but I'm still working to see what can be done. And maybe we can get a revised contract or get an industry change, with TransUnion, so that that could be reported. So that's where we're
Interesting.
at. It's in the air right now, I guess, because none of us want to accept that we have to only report positive.
Right.
So I'm still working on it, and I'm still working on it. So that one's a work in progress for sure. And yeah, and so many people have been confused with which way to, whether they are obligated to do it or not. And the new lease, I will add, the new lease does have a section for subject or exempt from the rent reporting. And so please use the new lease, the new AOA lease. It has that language in there. So, you'll need to mark one of those boxes. The tenant is not checking the box. You're marking it just like AB 1482. You're either subject to it or you're exempt, and you've been marking that all these years. Same with it's so the law is structured similarly, or in the lease, it's very similar. So you have to mark whether you're subject or not to it. And just because you're not subject to it doesn't mean that you can't add the lease addendum for positive rent reporting. So you may not
Right.
be subject to it, but you can still add that to the lease and reward people that are doing the right thing.
Jeff, since you brought up 1482 and that the fact that that addendum is in the lease and it needs to be checked out, do you mind if I touch on that real quick?
Please
I
do.
see that all the time. Landlords mistakenly believe that simply because the addendum is there, they're exempt from 1482, and that's not accurate. You actually have to physically check the box
Yeah.
for the exemption to apply. And so people send in cases all the time where they say, well, I'm exempt from 1482. And we look at their lease, we have to tell them the unfortunate news. No, you're not. You didn't check the box, or your manager who was signing the leases didn't check the box. So just make that, hopefully that is clear to people. It isn't simply that the language is in there that you're exempt. You actually have to check that box.
Yeah, well, Brown Eyes, I really appreciate the question because it brought out several different things that a lot of people aren't really aware of. So thank you, and thank everybody that's putting the questions in here. And um, single member LLC disregarded, owned by individuals revocable trust, owns 11 condos in one HOA complex. Does rent reporting apply?
So that's another great question. So this is perfect. This is exactly what I'm talking about. The way that that law is written is terrible. The answer is it depends on which camp you fall in. By the way, Jeff, I fall in the same camp as you do. But I've listened to other attorneys who have, reasonable grounds for their position. Listen to what the individual just asked. If those condos are all in a single building, I think it's unquestionable they're exempt.
Mhm.
But what if they're located within different buildings on the same property? Then it's questionable whether they're exempt because the language does say a residential building. There's no S on that. So
Right,
that's where that confusion comes in. And as I pointed out, there's no case law on this stuff. It was a poorly drafted law. It will probably be revised as time goes on. But again, in an abundance of caution, report or offer them the option to report. Let's put it that way.
right. And it needs to be done either by first class mail or with the self-addressed stamp
Right.
envelope and all that
Right.
stuff, or by email.
Right. If
So
you do it by first class mail, you have to include the self-addressed stamped envelope.
yeah, yeah. All right, Kathy, is there a standard form or something AOA uses to provide a tenant to inform them of positive credit reporting annually that might now be required? Yeah, so we have a rent reporting form. It's form 127. So 127A is positive rent reporting. 127B is for those that have assisted housing. And so those tenants, you can have the full rent reporting for them. So that's Kathy. And then, okay, Glenda, is it necessary for one unit condo to report rents? And
I would say no.
yeah, no, yeah, no, it's not. So, okay, RMP. With Section 8, can we report without a notice being sent? No, yeah, you still have to get their consent. Like
Right.
it's what TransUnion is requiring. And then like Experian, I know that they pretty much only do positive, and that's why we did TransUnion because they at least do positive and negative. Okay, can we get a copy of the PowerPoint?
Yes.
What did you say on that? You're going to give it to us,
I'll
and
email it to you guys.
yeah. So and then just write membership at aoausa.com, membership at aoausa.com, and then they'll get the PowerPoint to you that way. Okay, Sandra.
Jeff, can we jump backwards real quick for something? On the Section
Sure.
8 question about reporting, um, are you receiving resistance on reporting negative from that as well, where the law specifically
No, not at
says it?
all.
And
Yeah.
okay, it's just this poorly drafted new law.
Right. Yeah, because that one, yeah, 1157, you're right. It's like two years or more older, but this
Right.
one's getting the attention. I don't know. That one kind of fell under the radar on a lot of people, but this
Right.
one, not so, yeah, not. So Sandra, if your 1 year lease expires and the landlord does not renew the lease and continues accepting rent month to month, does the terms of the expired lease apply other than the agreed monthly rent?
Yes, when you move from a fixed term lease into a month to month lease, those terms in the fixed terms still remain in force.
Yeah, so
It's just
everything just
converted to a
kind of,
month to month, that's all.
yeah, everything just automatically goes to month, right?
Right.
Okay, Allison.
Well,
Can,
it automatically goes to month. If you're under rent control or a just cause ordinance, yes, it does automatically. There are still some leases out there that say in order for it to convert to a month to month, there has to be the exchange of rent. So not all of them are automatic. Most of them, most of the trade industry leases are automatic.
yeah, we took out a sentence or two so that people that have condos could evict, but if you let it go 12 months, then isn't it too late? Like you'd have to give them notice before the 12-month period. If
If you're talking about that you weren't going to I don't, if you're in a fixed term 12-month lease, I think it's too late. You can't give them notice that you're not renewing because the protections of the Tenant Protection Act kick in for as soon as that tenancy is 12 months old. Once
Right.
they've been there a year, so you could notify them that you weren't renewing it, but arguably, and I think it's a good argument, if you tried to terminate that tenancy and they've been there 1 year, they're protected by the Tenant Protection Act.
Yeah, if they've been there a year, it's over,
Right.
right?
It's too
Yeah.
late.
Allison, if an evicted tenant left behind a pet, are we allowed to call animal control or take the pet? Or do we legally have to hold and take care of the pet for the 15 days?
You know, that law changed. You used to have to hold the pet. Don't quote me on this, but I'm 98% sure that the law changed several years ago, allowing you to call animal control. I can dig into that, Jeff, and figure out. I'll send you some information about it, but like I said, I'm 98% sure now that you can call animal control and have them come pick it up because they're going to care for the dog while the tenant, doing whatever they're doing.
That's so sad.
Yeah,
Like,
I have
really
client. I can't tell you how many lockouts we've had where the client will call me and say the dog's there, but the tenant will leave the door open when they vacate, and then the dog wanders off. So most of the time you don't have to deal with it, but there are times where they leave the dog in a vacant unit with a bowl of food, and they go out and they lock it up, and the clients ultimately end up calling animal control.
Okay, Donna. If the 2025-26 rollback rents go into effect, will the landlord have to return rent raised after January 7th?
Yes, because it will be rolled back to that date. So they'll be owed a credit. I take that back. I don't believe that they will. I can, again, that's another one that I can look up. There's so many things I look up that I hate quoting. I used to be able to just say yes, no, can't do that anymore. I believe that if it goes back into effect, I believe that there will be a credit due, but I could be wrong on it. I will double check it.
I don't like like all questions are great. I don't like the if questions because then some people misunderstand and they're thinking that they have to do this or
Right.
thing. But yeah, maybe it would be prudent to put aside that amount for the just in case. But yeah, we got to fight. We just have to like
There are definitely
make the
laws.
phone calls and do the emails and
There are definitely
uh,
laws that state when something like that happens, the landlord is not liable for that overpayment. And they've
mhm.
gone into effect. But I just don't recall whether that provision is in that law. So again, Jeff, I'll read it as soon as we hang up and I'll shoot you an email.
Yeah. Okay, here's Darlene. I was impacted by the Eaton Canyon fire and sustained a total loss to my rental property. Based on your presentation today, I should take the money and run versus trying to rebuild, correct?
Um, I I can see how you would interpret my presentation that way. Um, as far as the Eaton is concerned, I don't know if this is true or not. I've had clients call me telling me that when they're talking to the city, they've had single family homes, and the city is telling them now they won't reissue permits for single family homes. They will only issue for multifamily because they're upzoning properties. I don't know if that's true. It's just that person's interpretation of what a clerk at a counter is telling them. But if you have a total loss, taking the money and running, I don't know. You'll have to do a personal assessment on that. But what I will tell you is being a landlord in California is not easy. It's not for the faint of heart. It's not for a mom and pop who just have one or two units and no economies of scale. So you'll have to do a personal assessment on that and figure out what you want to do.
Yeah, and that's the point for the politicians to take is that when they make it unfriendly, investment dollars will travel. And it's unfortunate. You end up with this is exactly how we end up with less housing,
That's
less
just exactly right.
that's exactly what happens. And I yeah, it stinks that sorry that you lost your rental there. And yeah, that's a tough choice for sure. So, okay, the broker with a heart. I'm in Northern California. Will these laws supersede existing local San Francisco strict, smaller, strict, similar, and applicable ordinances, or are they in addition to them?
So the ones that I talked about where I said, hey, this is LA City, this is LA County, those won't impact you at all. You'll be subject to your local ordinances. Um, Now, I typically what happens is Southern California uses Northern California as a model for their ordinances because Northern California has traditionally been more strict than Southern California. So I would look into your local ordinances. The state law will have to mesh with your local ordinance. So, for example, that requirement that you take third-party payments, that's a state law. So you are going to be required to accept those. Like I said, there's more to that law. There are certain requirements that the tenant has to meet before you're obligated to take that payment. But that is a state law. You will have to comply with it. And if your local ordinance has that, for example, an anti-tenant harassment law component to it, you'll have to read that and see if the two mesh together and if you're going to be forced to take those payments as well.
And so, yeah, we covered a lot of different things. So when we covered the tenant screening stuff, that's state law. He when we covered the AB 246, that's the one that's specific to LA and Ventura. And then let's see, what was the other one? 436 covers the entire state, right?
You mean 246?
Yeah. No,
246 does.
430. 430. Oh, did I write it down wrong?
No, you probably didn't. 246 covers only Los Angeles and Ventura.
Oh, right, right. Yeah, 436 is the one that's reinstate an evicted tenant.
Oh, yeah, yeah, that's a state law.
That's state.
Yeah,
Yes. A lot of what we talked about today was state,
yeah.
with the exception of that 246 that's specific to LA and Ventura County.
Right. The reason I brought in the specific locals is because they're trends. For example, right to counsel, right? It started off in one area, and now it's, believe it or not, it's moving across the entire country. LA just passed it. Every tenant gets an attorney when they're being evicted. It's a trend that grows, especially when it passes and one municipality says, yeah, it works well here. You can see that changing. So the anti-tenant harassment ordinances, you can really anticipate those going statewide. I wouldn't be surprised if the state comes up with a tenant anti-harassment ordinance as well.
Mhm. Yeah, well, last time we voted down rent control at the ballot box, then they came up with AB 1482. So
Right,
this 436 is I think that would be the one that would be it that they would try to get going. So
right.
everyone really needs to write, call, make the calls and do all that. And we're getting some new, one of the criticisms we've gotten is, hey, make it easier for us to get those letters out. And so we just identified some software, and we're going to be getting that installed so that when we have an action, like a call to action, you'll be able to just click, and then the email will be sent. And I think that's going to be really, really cool to have that. And anyway, so
Jeff, real quick, I did some real quick research about that rental increase. And
mhm.
I just want to read this to the members. It says, notwithstanding subdivision A, which says you're not going to be able to implement rent increases. An owner of residential real property that would otherwise be subject to this section may increase the rental rate for a dwelling or a unit in accordance with a notice of rental increase issued on or before January 7th. So what it's saying is if your notice of increase went out on January 7th or before, your increase is good. Even if the law goes into effect, you won't have to undo that increase. But it's silent on whether you'll have to return the money. If let's say your increase went into or was served on January 8th, it's saying that if that law goes into effect, you're not going to be able to implement that increase. And if you have already, let's say 30 days passed, you've implemented the increase, and yet the law gets passed, it's silent on returning the money. So again, if you always want to be in an abundance of caution to keep yourself out of liability, like Jeff said, plan for it ahead, put that extra increase into a reserve of sorts, and if that law passes, be prepared to credit the tenant back that money.
Incredible. I mean, just incredible.
It's like I said, these aren't landlord-tenant laws anymore. This is warfare.
Yeah,
This is absolute warfare by Sacramento and local against landlords.
right. Okay, Mark, is there a particular proposed law that may trigger a Supreme Court decision on unlawful taking?
Takings is a very complicated area of law. There are different types of takings. There's monetary takings, there's administrative takings, there's a lot to that. I am unaware of specific taking laws working through the system right now on their way up to the Supreme Court. What I would encourage anybody, that's a great question, by the way. I know there were taking cases. I don't know what happened with them because it's just not my area of law. But what I would suggest people do is follow the Pacific Legal Foundation, sign up for their newsletter. They're a fantastic organization who does nothing but fight for private property rights. And so that's one of the organizations that if you've got money to donate, they're a pro bono law firm. They do it for free, but really it's not for free. They do it with donations and things of that nature. But they have a huge string of successes, including in front of the Supreme Court. That is one of the major firms that protects private property rights. So I would, like I said, sign up for their newsletter and follow them. And you can email them. They're pretty responsive. I would ask them about the takings. I've seen them file takings cases in the past.
Right. And yeah, when the county had the eviction moratorium, we filed that lawsuit. A lot of us are using, a lot of the associations use some of the same attorneys
Mhm.
that specialize in that. And we hear you. And when you look at it objectively, it looks like, gosh, how could that not be? But then whatever case law that there is and whatever, whatever's been decided in the past, it seems like lots of times where we would all want to have a lawsuit, it's not even a starter.
Well,
Uh,
I would add to that that it's important to remember that housing is considered such a vital component of society that even the Supreme Court of the United States has said that local municipalities have the right under their police powers to regulate housing because they're so vital, because we don't want a situation where we have untold numbers of homeless people in the streets. So you give them the police power to do it and couple that with the complexity of a takings lawsuit and things get ugly for landlords very quickly.
all right, Teresa, can we ask current renters to sign an agreement stating that accepting third-party payments does not create a new tenancy?
So, great question. Under state law, that's actually a requirement. If a tenant walked up to you and said, "Hey, my charity is going to pay my rent this month," you don't have to accept it unless the tenant shows up with a letter, and the letter is right in the code what language has to be in there. The letter specifically states that by accepting this money, I am not creating a tenancy. So if they showed up with that letter, then you would have to take the money from the third party. If they don't show up with that letter, you do not have to take the money. If
All
you
right.
want to take the money, I do have a bit of a reservation about that. It may be good this month, but the fact that your tenant is using a third party to pay their rent, and let's say you take it this month, that those third parties typically have a cap on how much they can give any one individual. One, you're going to be in the same boat, whether it's today, 3 months from now, 6 months from now. That tenant is obviously unable to pay their rent on their own. So while it may be enticing to take that money today, I think you're just kicking a problem down the road. But you'll have to analyze that situation as it pops up and make whatever determination that's in your best interests at that moment.
Oh, Darla's asking about which newsletter, it's Pacific Legal Foundation.
Yes,
And yeah, like every Friday, I get something in just about every Friday, I get something in my inbox from
yeah,
them, just things that they're working on.
great
And
stuff.
our PAC has donated to them once or twice when they're, trying to
Fighting the
encourage,
good fight.
huh?
When
Yeah,
they're fighting the good fight.
yeah,
I mean, they're always fighting the good fight, but fighting our good fight.
right,
Yeah.
right. All right, Ray, single family home in the city of LA, vested under corporation, need to evict longtime tenant to build 6 or 7 units. How much relocation fee do I have to pay to the tenant?
I don't know. There's different tiers. What you need to do, you're a single family home, but I think he said it's owned by a corporation, correct?
Yeah, he did.
Okay. So whether it is or not, you still fall under the City of Los Angeles's just cause ordinance. So what you're going to have to do is to build what you're going to, if you want to get rid of that tenant, it would be under what they call the substantial remodel demolition component of it. You're going to have to file a declaration of intent to evict with the city. The city will go out and interview the tenant, and based on the city's criteria, they will determine exactly what those relocation fees will be.
Yeah. But use an attorney, right?
Yeah, don't that the declaration of intent to evict, it's tempting to hop online and just fill it out yourself and submit it. If you're going to do that, that's fine, but at least talk to an attorney first and understand the nuances that apply to your specific property before you fill that thing out.
Yeah. All right. Hey, Simply Chiral, good to see you
Hi,
again.
Sherelle.
If we have an existing lease that is now month to month, do we need to give tenants an addendum about the rent reporting information since it is not stated on the original lease?
Yes, you have to offer, as of April 1st, you were required to offer them that option, that opt-in letter. And
Yeah,
I
so
believe AOA has it.
yeah, no, yeah, I mean we have the form and
Uh,
it's in it says option credit reporting option, and so yeah, it's an addendum to the lease kind of, but yeah, we use it as an addendum to the lease. I don't know.
Bottom line is by April 1st, well, as of April 1st, you have
Yeah.
to offer that to them. So I would go ahead and do it right away.
Yeah, it's just emailing them is all that you really need to do, offering it to them.
And if you don't have their email, mail it, but mail it, I mean, unless you can personally deliver it. But if you can't, mail it, but include a self-addressed stamp envelope. And I would actually take a picture of the whole thing to prove you, like a photocopy to prove that you did it.
Yeah. Okay, Sharon, if the property is in the city jurisdiction under LA County, does the landlord need to follow AB 246? So 246 hasn't passed yet, right? So
Right. And I didn't even understand that. If it's in the city but falls under the county, so I guess she's saying it's in an unincorporated area. 246 is a state law. Oh, I see what she's saying now. It's a state law, but it impacts the county. And yes, if it passes, it's going to apply to every residential rental unit in the entire county.
right, regardless of what city it's in.
Right. It has no effect whatsoever that it was out in, West Covina and was not impacted by the fires in any way, shape, or form.
Darlene, hey Jeff, how about selling t-shirts to members to appear at these town hall meetings to fight these ordinances? Great idea. And yeah, let's do it. We did hats last year and we should do the shirts and get that going.
Jeff, I did love that picture in the LA Times. I don't know if you saw it when the city of LA decided against implementing that eviction moratorium for the fires. The picture was the woman, several people standing there with the yellow piece of paper that said "We House LA,"
Mhm.
just like Tenants Union LA. But I think it's a fantastic idea. Show up in t-shirts, bright yet red, bright yellow, bright green that says "We House LA."
Yeah, yeah. And it was really cool because there were 3 weeks in a row that we asked people to show up and people did show up
They did,
and
yeah, and they won.
it made a difference. So guys, like some of you feel like you're just totally losing at every turn, but think about it. Like we defeated statewide rent control at the ballot box, and then
Yep,
for
three
LA,
times.
yeah, 3 times, right? 3 times we defeated that thing, and then also just recently with that. So don't let it be a self, defeat like a self-defeating thought become a prophecy in your life that just
Right.
where you give up before you really need to give up. So let's
Yeah, if you're going to hang on to your investments, you have to make the time to show up. You can win.
yeah,
It's hard. It's very difficult because who can take off from work like this? Who can attend these meetings? But if you're going to hang on to these investments, I mean, there's big consequences involved. It can be done.
hey, Mike, thank you so much for your time.
You are very welcome, Jeff. I
And
appreciate
I'll
it.
see you next week.
See you next week. Thank you so much.
Okay, thanks everyone. We'll see you
All right.
next week at the LA Convention Center. Take care. All right.